Good morning, everybody. I think we're going to make a start and welcome everyone to this morning's webinar on GDPR, debunking GDPR myths. My name is Jeremy Robson. I'm the managing partner of M&A Partners, and I'm joined this morning by Alex Saunders of Leathes Prior Solicitors. Alex is the brains of the outfit, so please direct all of your questions at him. But between us, we hope to debunk some of the many myths surrounding GDPR. We've also got Gary Brown here, who's one of M&A's technical gurus, and Gary's going to be fielding any questions or comments and things that you want to send in. By way of a little bit of background, I, as managing partner, was tasked with looking after M&A's GDPR compliance last year, and I did a whole load of research and was fortunate enough to attend a seminar at the end of last year where Alex was speaking, and it was clear that he was somebody who knew his subject. And from then on, we engaged Alex, and he has helped us with our GDPR journey to broadly where we are now, and hopefully be compliant in about a month's time. But one of the things that we both noticed as we worked together is that there hasn't been a subject like GDPR where there's so much misinformation, there are so many myths, and hence the reason we thought this morning's webinar would be helpful for people so that they could find out a little bit more, ask some questions, and hopefully go away a bit better informed. The way we're going to run it this morning, we've come up with about half a dozen questions that I think will be our sort of starter for 10, if you like, which will deal with areas such as consent, marketing, retention of personal data, security, data breaches, and data protection officer. And then at the end of that, we'll open it up to the floor and let people come in with their own questions. And certainly, as we go along, if you've got something you want to find out about consent or security, do come in with a comment as we're going along. Enough from me, let's get started. So first question we've got relates to consent. Do I need consent from an individual when I'm using their personal data in every situation? Is this correct? Are there any other ways that I can use personal data without needing to get consent? Alex, over to you.
Thank you, Jeremy, and morning, everyone. It's a pleasure to have you with us this morning. So starting with consent, consent is one of the areas, as you rightly say, there's a fair bit of poor or overwhelming information around this area. And one of those key areas is consent, when you need to get it, when you don't need to get it. So the starting point is that consent is one way to use personal data under the GDPR, but it is not the only way. There are actually 6 bases on which you can process personal data, and this exists not only under the GDPR, but indeed under the Data Protection Act, 1998, which has been around for just under 20 years. So there will be a number of ways that you can use personal data, and consent is only one of them. Broadly speaking, I'm not going to go through all 6, but the main ones that you're going to be potentially relying on is, for example, if you've got a contract with that individual. If you've got a contract with the individual, then you do not need consent to use their personal data. So to use that in an example, Leathes Prior obviously need my personal data. They need to use it to communicate with me, to carry out performance reviews, to pay me as well, which is quite important. So in that situation, clearly they do not need to go out and get consent from me to continue doing all those things. Because the question there would be, well, what about if I said no? And if I said no, they would not be able to continue using my personal data under the GDPR. So if you have a contract with the individual, then you can continue using their personal data without consent. Likewise, there's another ground, which is the legitimate interest ground, which some of you may have come across before. The legitimate interest ground is effectively sort of a catch-all basis for processing. So if you have a legitimate and genuine reason for using someone's personal data, then you do not need to get their consent. However, legitimate interests, or your own organisation's legitimate interests, need to be weighed against the individual's legitimate interests. And therefore, the legitimate interest ground is slightly more of a grey area, because you need to weigh up what's the potential risk and harm to the individual compared to your own interests. So to use that in an example, CCTV cameras would be a really good example of where you would have a legitimate interest, which is to keep your premises safe and secure. Now, clearly, in that scenario, you would not need to go out and get consent from every single person who visited the site, because that would just be impractical and wouldn't work. And obviously, if there was someone who was stealing from you, then they're going to be unlikely to give you their consent. So in that situation, you would not need consent. You would rely on a legitimate interest ground. However, you need to weigh it up against the potential harm to that individual. So, for example, if you somehow managed to get a camera that was trained on a particular individual to follow them around, which is obviously going to be very intrusive, in that situation, then you may not have a legitimate interest, because that individual will say, well, actually, you're being quite intrusive. So there are a number of grounds on which organisations can use, store and collect personal data. Consent is only one of them, but for, I would suggest, probably 9 out of 10 times that you're using someone's personal data, you won't need consent. So that's an area where there's quite a lot of misinformation, and certainly it's likely that you're going to be able to go out and get have another basis on which to rely.
Just to sort of summarise there for a little bit, consent is only one of the issues that need to be considered when we're looking at use of personal data. If you have a contract with somebody, you can therefore continue to use that personal data without their consent. Legitimate interest, I think, is something that we are going to be talking about throughout this, in terms of justification and working out whether there is a legitimate interest. Sometimes it's clearer than others, but that's something we will be coming on to later, I'm sure. We've just had one question which I think, neatly summarises some of the issues here. Client data for customers where they might have bought some equipment that's under warranty. Now, that clearly is one where warranties can last for a number of years. And I'm guessing that in this situation, because you have a contract, you are able to use and retain that personal data until such time as the warranty may expire.
Yeah, absolutely. And that's actually a really good example of where the contract basis would come into play. Because, of course, if you no longer were able to use that client data, or if you were relying on consent, and remember that individuals can withdraw their consent anytime. How could you contact them if you needed to, for example, explain any changes in the terms to their warranty, if you needed to contact them for any other reason in relation to that warranty? So absolutely, that's an area where you'd be entirely entitled to use customer data if you have a contract with them. And you would not need to go and get consent to continue using that for the life of the warranty.
And I touched on it a second ago, and again, it's something that I've become more and more aware of. Ultimately, if you can justify why you need to keep personal data, that is at the heart of GDPR, in terms of, if you were to have a problem, you can then say, we have thought about this, we documented it, this is the justification. And clearly something like a warranty is something whereby you're going to want to say, we feel that we will possibly need to get in touch with these people later, and that is the justification for keeping the data, their information.
Yeah, absolutely. And of course, you could potentially be in breach of that warranty if you don't retain that information, because you can't administer it. If someone made a claim under the warranty, well, if you deleted all their data, then you couldn't respond to it. So that's a really good example of where consent would not be an appropriate ground for processing under the GDPR.
Perfect. Let's move on to the next question, which again touches on consent, but this one's a little bit about marketing. When am I most likely to need to get consent? Will I need it for all marketing? If so, what do I need to do to get proper consent under GDPR?
Absolutely. So marketing, I've been giving various talks, presentations and seminars. Marketing tends to be the area where people look most scared, should we say. But actually, again, there's a lot of bad information around marketing consents, but it is absolutely right that consent is probably going to be the most relevant ground where you are marketing. So broadly speaking, you need to look at marketing in two categories. You need to look at it as business to consumer facing and business to business facing. Now, in most cases, business to consumer marketing is going to require you to go out and get consent. And I'll discuss how you get valid consent in a second. There has been a recent bit of guidance from the Information Commissioner's Office, the ICO, who are responsible for governing all of this in the UK. And they have actually said that business-to-business marketing is likely to be an area where you can rely on legitimate interests. And in actual fact, the GDPR does specifically state in recital 47 that direct marketing can be a legitimate interest. So that's broadly speaking how you'd want to split out marketing activities. Now, where you need to go out and get consent under the GDPR, one of the biggest changes is the threshold that is required for consent. So in order to obtain valid consent, that consent needs to be freely given, it needs to be informed, it needs to be for a specific purpose, it needs to be unambiguous, so the person giving consent understands what they're signing up to. And most crucially, under the GDPR, the biggest change is that it now needs to be given by a statement or affirmative action. And the reason that that is, practically speaking, such a big change is that no longer will silence, pre-ticked boxes or opt-out boxes or some kind of inactivity constitute valid consent. And the ICO from the off have been very, very clear about this point. So if you are needing to go out and get consent for your marketing activities, then you need to make sure that you do so validly, because you're really only going to get one bite of the cherry. So you don't want to go out and get something that then isn't even going to constitute valid consent under the GDPR. So you effectively need to go through and tick off those criteria. So just using that in sort of a practical scenario, for example, so freely given means that you can't really go out and get consent from people who are relying on you for something. So for example, getting consent from your employees, as we've already talked about, it's going to be very, very unlikely that you're ever going to need to do that because you're going to be relying on the basis of a contract with them. But if you had to, then there's an argument you couldn't even get valid consent from them, because if they said no, that could potentially have some employment implications. Likewise, it needs to be for a specific purpose. You can't just get some kind of blanket consent for everything. So it's those sorts of things that you need to consider when you are sending out your marketing emails to obtain consent.
Question that's just coming from Craig. What about data already collected in this way pre-GDPR? And I think I know the answer to this one, but it is, I think, I go back to previously silence meant it was okay. You now have to be able to show affirmative action. Do you just want to address Craig's?
Yeah, no, I think that's a good question from Craig in terms of, again, this is an area where there is some misinformation out there. What the GDPR does not say is that you need to go out and get fresh consent, come what may, post 25th of May, which is when the GDPR is due to come into force. But what you need to do is you need to establish that you have got valid consent under the new GDPR standard for all consent that you're currently relying on. So if you have previously relied on silence or you've relied on some kind of pre-ticked box, then as we've just said, that is not going to meet the criteria for consent under the GDPR, and you will need to go back and get fresh consent that meets the proper standard. So on that basis, not necessarily a question of going out, but it's how comfortable are you that the consent you've already got actually meets the criteria under the GDPR. And if you're comfortable and if you can evidence that and you've got a record either on your CRM system or through some other means, then that's absolutely fine. You can continue relying on that. But what we're finding is most clients and organisations that we're advising have got consent in some form, but generally can't trace back to where they got it from. They may have bought it from lists, they may have, got it through some kind of, opt-out tick box or silence, or it was included in their terms and conditions. All of those things will mean that you need to go out and get new consent under the GDPR.
Charles, is just you mentioned CCTV in the first bit. Question from Charles: will the use of a CCTV camera need to be registered, as has been the practice under the current regulations?
So I think what the point here is registering as a data controller on the ICO website, that you pay a fee of around £35 to do so. That's all actually going under the GDPR. So there is no longer this sort of central registration. Unfortunately, you still have to pay a fee, but there's no longer going to be kind of a data controller register in the same way there was beforehand. So the short answer there is no, but you will need to take some practical steps in terms of obviously putting up signs to say that you're recording, which is fairly standard. Telling people who visit the premises that they are being recorded. So, for example, particularly employees and customers, including that in some kind of privacy notice, and making them aware, and obviously recording that in your internal data protection policy and your processing activity register, which is documents that will come on, no doubt, to talk about later on. But it's effectively a question of recording what you're doing, recording why you're doing it, and recording what lawful basis you're relying on, all of which are incredibly common sense. But as I've said previously, the GDPR is a bit of a paper exercise, and therefore it's about recording those things. Yeah,
and if there's one thing I've learned in the time I've been dealing with this, if you keep a record of decisions made, it potentially is going to be very valuable in the future if you have a problem, because it shows the justification. This is another word that keeps cropping up. How can you justify stuff? If you've thought about it, recorded it, and got documented evidence, that is going to be key for you. Chris has asked, is there any issue with direct contact details when marketing B2B, i.e. Fred at M&A Partners, email and direct line?
So that is personal data, because it's something that can identify an individual, and probably just worth pausing for a second for those who haven't kind of come across that phrase before. Personal data is what's covered under the GDPR. And personal data is anything that can identify a living individual, be it a name, email address, telephone number, medical records, IP address. It's a very wide definition. Anything that can identify someone when you are doing something with that information, the GDPR is triggered. So it's probably just worth clarifying that. So in this scenario, even though it's a business address, it would be personal data. But the question then is, if you're marketing to them, can you rely on the legitimate interest? And what the ICO guidance that came out at the end of March seems to be saying is, in most cases, yes, but you will need to look at, well, firstly, you need to identify what your legitimate interest is, which is, of course, is going to be marketing and commercial benefit. And then you're going to need to look at the potential risks to the individuals in question. So if you're doing B2B marketing to invite people to events, well, is there any risk to that individual? I suspect in most cases, no, but obviously if it's particularly intrusive or particularly unusual marketing, then there's more likely to be a risk to the individual. So it's effectively a balancing act. And as I said to start with, the legitimate interest ground is one of the grayer areas, and we are yet to see exactly how that's going to be enforced by the ICO, and we'll get a much clearer picture of that post 25th of May.
And certainly we've taken advice from Alex at M&A in terms of looking at consent, and at the moment we are not going to ask consent from all the businesses that we have connections and contact with in terms of marketing, and the legitimate interest, because ultimately we need to be telling people about things, and therefore the business to business thing we feel pretty comfortable about. Will's asked, do you have a standard form of statement which we could all use for asking for consent, i.e. the correct legal word? I mean, is there a correct legal wording?
No, I mean, that's an interesting question, actually, and I've come across this before. there isn't any correct legal wording. And in actual fact, bearing in mind the fact that it needs to be unambiguous, the less legal jargon, the better.
Yeah.
What you need to make sure you do is that you make sure it's absolutely clear what you're using that information for. So if it's to offer similar goods or services, then fine. You need to ideally link it into your privacy policy. So to say, for more information about how we're using your personal data, see here, see our privacy policy. And the privacy policy then deals with all the detail that needs to go in, exactly what data is being collected, how it's being used, and that sort of thing. So there isn't any specific, one size fits all wording for consent, but ultimately it's just a simple statement linked into a reference to the privacy policy, being clear about what it is that you're going to be using it for and what they're actually giving consent for. And as long as you can tick those boxes off, the ICO have released some guidance around this, so it's worth having a quick look on their website. And they've just said something as simple as, I would like to hear more from you about the other goods and services that you offer. For more information, see our privacy policy.
Linked to marketing, and there's an interesting one here from Kerry saying, we contact businesses as potential sponsors. We keep this on file to know who we have contacted in the past, even if they say no. This seems a legitimate interest. Is it okay to keep business data like this as they have not given their consent? Is sponsorship same as marketing?
Yeah, I think it, broadly speaking, would be. Obviously, we'd need to drill down probably a little bit more into the specific facts. But generally speaking, what we're also having a look at retention of personal data. Now, at this point, I should stress, if it is business information, if it is MA Partners LLP, it is not personal data. So keeping a list of organisations is no issue, because actually the GDPR is almost entirely irrelevant, because that's not personal data. If it is personal data of individuals at an organisation and they've said that they don't want to hear from you, my view is that you would struggle to justify why you're retaining that data other than as sort of an unsubscribe list. But if you're continuing to contact them, the GDPR is specific that irrespective of whether you're relying on consent or a legitimate interest, anyone has the right to object to direct marketing. So if they have objected, you need to stop contacting them, and that is basically sort of set in stone in the GDPR. It's fairly clear.
We've got a question here about B2B business, but our blog is public. People can subscribe to it, at which point we may email them with marketing content. Some people may sign up to the blog with private Gmail, etc. type addresses. Should we go for consent to cover all bases, or can we assume this is all B2B and don't have anything to worry about?
Yeah, if organisations want to take the belts and braces approach, then of course consent is always an option. Important to say that consent gives the individual heightened rights under the GDPR that they wouldn't have under legitimate interest. So, for example, they have certain rights to data portability, they have rights to withdraw consent, and various other things. So you can absolutely go for consent, and as long as you record that and get it in a valid way that we've just talked about, then that's absolutely fine. I would say, though, that if someone is subscribing to a newsletter on the website, that's probably in itself consent, because they are saying, I would like to hear more from you by signing up to the website. So it's an affirmative action. And if you then include some kind of reference within the privacy policy that this is what you're going to be doing, and this is the information notice that you've got, then that's going to be the best way to deal with it, to say, if you subscribe to our newsletter, we will continue contacting you about various things because you have asked us to. And that is, in and of itself, absolutely fine. As long as you tell them what you're doing in that scenario, then that's not an issue.
Okay, let's move on to the next slide. I've heard that I need to delete all of my documents that contain personal data and start again. Is that true? If not, how long can I retain personal data?
Yeah, so data retention is yet another kind of area that has caused some confusion. But actually, the rules around data retention under the GDPR are very, very similar to the current rules that exist under the Data Protection Act that have been around for the last 20 years. So there really isn't a huge amount of change in this area. What the GDPR says is that you can only keep personal data for so long as you need it for the reason that you first collected it. So what that's going to mean in practice is that you need to pull together some kind of sensible policy that says, well, what categories of data have we got? How long do we really need that data? And most importantly, Jeremy, as you've already touched upon, justifying why that personal data is still needed. So to use that in an example, employee data. The moment that that employee leaves, you do not have to delete every record of them and pretend they never worked for you.
And I believe that has happened.
Yeah, depending on the circumstances that they leave, I suppose. But because there's going to be a number of reasons why you're still going to need that data. For example, you may need to defend a legal claim. You may need to establish that someone's been paid. You may need it, and you almost definitely will need it, for tax, audit, accounting, reporting purposes. So on that basis, you still need that personal data. So it's going to be a question of drawing up a sensible policy and saying, right, we still need this for a particular period of time. And I hasten to add, unfortunately, that the ICO are never going to tell you exactly how long to keep certain documents for. So this is all down to what you can justify. And providing that you can justify it and you've recorded the reason, so in the circumstances where you're keeping former employee data for those reasons that I've just mentioned, then my view is that the ICO are rarely going to challenge that reasoning. If you haven't justified it and you don't have any kind of record of it, then it could well be challenged because the ICO will say, well, actually, we think that's too long and we've not seen any justification to the contrary. So it's ultimately coming up with your own policy and determining how long you think it's required. So, I mean, in the case of employees, you know, HMRC can go back 6 financial years plus the current financial year, and therefore a number of organisations have been saying, well, keeping it for 7 years seems like an appropriate amount of time. The only thing I would say to that is that you probably don't need everything for those 7 years. So you don't need, for example, you probably wouldn't still need bank details at that time.
And it keeps coming back to this word justification. And I think this is a point I would certainly stress, that ultimately people need to give thought about the personal data that they hold and why they hold it. And then, as Alex was explaining there, how you can justify holding it for a period of time. Because ultimately, if you have a problem in the future, the ICO will possibly need to be informed. And if they need to be informed, one of the first things they'll ask for is, well, what have you decided regarding retention of personal data, be that employees or clients or whatever? And if you have nothing, you're going to have a problem. If you have actually said, well, we thought about this and we felt that we should keep it for this period of time, they may turn around and say, actually, guys, that's too long, but at least you have given it some thought and can therefore give it an element of justification. So that's something that I think certainly from the other side of the fence, in terms of what we're doing, we're looking at all of that.
Yeah, absolutely. I think one action point that all businesses can take away from today is go away and pull together a spreadsheet and call it a retention period register, which effectively categorizes the different categories of personal data that you hold. So, for example, employee data, customer data. You may want to be a bit more granular than that, and then record why you're using it, how long you're intending to keep it, and why you're intending to keep it for that period. And I would love to say, Jeremy, that that's something that only lawyers can prepare, but actually it's a glorified spreadsheet. And of course, I'd be more than happy to assist businesses in advising on what goes into that. But ultimately, that's going to be a simple, practical action point that I think people can take away from today.
Questions coming in thick and fast. We're just jumping back to marketing. What about cookies and data we get from users browsing the website? Is our cookie policy popping up on the website enough?
Yeah, so cookies are an interesting one because cookies are not always personal data. As I understand it, there are sort of two categories of cookies. Ones that I can identify a person, and ones that can't identify a person because they attach to, a device, and obviously that device could be, could be company property, for example. So, absolutely essential to have a cookie policy, but perhaps even more importantly, having a website privacy policy that sets out what data is being collected, and in this case, it's going to be technical data, because I suspect IP addresses, browser type, things like that are also going to be captured, and explaining why you use it. So privacy notice, telling them why you're collecting it and what you're doing with it is going to be really, really crucial there. So a combination of privacy notice, our privacy policy, and cookie policy are going to be the two key documents.
Good. Jumping back a little bit again, you mentioned the Information Commissioner's Office, ICO. A couple of questions, one from Kerry. You mentioned ICO registration. Will every organisation have to register with the ICO in the future, as before there were exemptions? And also Charles is asking about, does every data controller and data processor need to register with the ICO?
So the exemptions will still apply in the same way that they did beforehand. So, for example, if you're doing purely marketing, I believe that's one of the exemptions from the registration process, but no longer will it be a kind of a central register, but rather just something that you pay into. That is effectively like a tax. But there will still be exemptions that apply. The reality is that the ICO, as you might expect, are slightly behind on all of this. So the full details actually haven't even been released at this stage. There is some guidance online that people can see, but as I'm sure you can imagine, with the Cambridge Analytica issue, amongst various other things, they are obviously, the GDPR being the main thing, they are slightly behind on that. So what we've been told, and I've contacted the ICO directly on this point, is that the ICO will be writing to your business if they believe that you need to pay. Don't bank on getting that before the 25th of May. Because as I said, they're quite behind. And when they write to you, they will tell you what band they believe you fall into, which is based, broadly speaking, on turnover and number of employees. And then you will be able to say, well, you believe an exemption is going to apply. So they're going to take a positive step to get in touch with you. That's what they've communicated to us.
Good. A couple of questions relating to sort of marketing and consent. One from Aliona. We collect personal data from service users to be able to offer them the support service they are after. This fits into legitimate interest. However, we then use their personal data to invite them to become friends of the charity, volunteer, attend events, donate. I believe that now we will need to obtain consent to be able to continue to do so. Am I correct?
Yeah, most likely, because obviously when service users are signing up for the service, then you can use their data to provide that service without consent, because you have effectively a contract for services with them. Even if it's not written down, it's still going to be a contract. What they are not then giving you is the right to use their data for any other reason. So that certainly sounds like a scenario where consent is going to be required. Obviously, as with all of these things, it may be that you need to drill down into the detail a bit more. But in that scenario, it sounds to me like consent is going to be necessary.
Okay. And another one that I've just seen, I think from Will, which I'm sure will sort of cover a lot of people, social media, Twitter, Instagram being used for business. Are you infringing the regulations by tagging people in posts?
Ooh, that's an interesting one. I've not had that one before. Will you be infringing by tagging people in posts? Well, if they're already signed up to Facebook or Instagram or whatever it might be, and you tag someone in a post, then you're effectively you're using their personal data in a way that they would expect, because by signing up for a social media platform, you would expect someone to tag you in a post, and they can probably change their own privacy settings to turn that function off. So I would suspect not in almost every case.
Okay. I think I can probably answer this one, but from Alex, what should I do with the data we have on individuals in our CRM who have unsubscribed from our email list marketing campaign? Can we keep them in the CRM as do not contact, or do we need to completely remove all of the profile data?
Good question, and you absolutely don't need to remove all of their profile data. In actual fact, the ICO guidance says that you should keep what they're calling a suppression list, because actually you need to keep details of the individuals who have unsubscribed, because otherwise you'd be in breach of the GDPR if you then contacted them again. So no, you can absolutely keep them, but remember, you can only keep what you actually need for that particular reason. So you don't need their bank account details, or you don't need their, extensive personal data. Really, all you need is an email address, maybe a telephone number, and their name and their organisation.
And if we look at the next question, actually, because the next topic we've got is security. Do you have any suggestions for security measures that I can take? Lots of people are saying that under the GDPR, I need to have two-way encryption for every email that I send. And I suppose, just going back to Alex's question, ultimately, this is one of those issues where the more information you have on people, personal data, potentially the more of a problem you might have if your security doesn't work. And so that's just something else, I guess, to be considered in all of this issue relating to security.
Yeah, that's a really good point, actually, Jeremy. In terms of sort of potential data breaches, would those individuals be surprised, or would they reasonably expect you to have that information still on file? Let's say that they've unsubscribed from the mailing list. Most individuals would expect someone to still have the name and email address so that you're kept on that unsubscribe list. But what they wouldn't expect is any further information than that, because it's simply not necessary for that purpose. So it's a really good point, and we're seeing a cultural shift towards actually thinking about it from the other side of the fence, which is not how can we hoard as much personal data as possible, but realistically, do we need this? Because the more you hold, the more chance there is of things going wrong.
And again, that's a really good point here, which is that ultimately, all businesses who hold personal data are now, after the 25th of May, significantly more accountable for that. And therefore, yes, we all need to hold it, but dare I say, I think we're all guilty of the fact that in the day and age that we live in, with technology as it is, it's just been far too easy to just keep data, not have to look at it, weed through it, sort it. And we now need to be a bit more recognizing that actually we have to regularly look at this stuff and think, do we need to keep this? Can we justify keeping it? Yes, we need to have personal data, but ultimately we mustn't just hoard it and forget about it.
Yeah, and there's a real reputational point here as well, which is actually that, as everyone on this webinar and lots of people around the country are really starting to pick up on this kind of GDPR bug, if you like. It's very much the hot topic of the moment. And actually, we're already starting to see lots of clients get queries in from their customers saying, "What are you doing with my personal data? Are you doing this? Are you doing that? Can you tell me? Subject access requests are going to be more prevalent as well." So there's a real potential ability for organisations to cash in and enhance their reputation if they are doing the sorts of things that we've been talking about. And actually, I think that's got a lot more credence with individuals than it probably did 5-10 years ago. So there's a reputational point there as well.
Fine. Just addressing the email, because we've got a question from Ian, which we'll come on to in a second, but in terms of email encryption, all of those sorts of things, can you just shed some light on that?
I can indeed, yeah. So complete nonsense that you need two-way end-to-end encryption on all emails. I've included that question there because it's one I've been asked more than a few times. I'm fairly familiar with the GDPR text now, and nowhere in it does it say you need two-way encryption. What the GDPR says is that you need appropriate security measures. And what's going to be an appropriate security measure needs to be taken into account the size of the organization, the available resource, the available technology, the type of personal data that is being processed, and the volume of personal data that's being processed. So not all organizations are being judged by the same yardstick here. So end-to-end encryption is, of course, an incredibly secure way, but I don't know if anyone's received an encrypted email before. They can be quite tricky because you effectively get two emails. You get one with the file and another one with the password. So it's not required. There's some simple steps that all organizations can take that are not going to be particularly costly. So things like access control, making sure that only those people who need to see particular documents have access to it. Most obviously things like payroll records. Just simple things like, locking doors, considering whether or not organization, bringing your own device or employees bringing their own devices is still a good idea. Considering whether or not data is being transferred on USB sticks, and if they are, ensuring that there's at the absolute minimum some kind of password protection. So it's those simple steps that organizations can take and implement, and again, come back to record, in order to show that they are taking appropriate security measures. So those are the sorts of things. There's a slightly more nuanced approach that needs to be taken here.
And interestingly, at M&A, we've looked at all of how we correspond with our clients, particularly like emails. And I think one of the things that is a function of this whole GDPR journey that we're on is to recognize, particularly in areas like payroll, that information that we are exchanging with our payroll clients needs to be handled in a certain way. And we are now looking at password protecting and encrypting all attachments to emails. We're trying to get more and more of our clients to use the secure document exchange, DocSafe, that we use for emails and things like that. So while, as Alex has pointed out, you don't need to encrypt emails, an awful lot of what we are now doing and will be into the future will be just increasing and improving the security of that. Just going back to Ian's question, what about emails to from ex-employees? We have problems with defining a retention policy for this.
Well, I
guess it goes back to justification.
Yeah, if you still need their email address because you're contacting them about something that happened whilst they were there that relates to their employment contract, and you still need it, then you can still use it. You're not expected to just delete and, as I said before, forget that person ever worked there. So, I mean, ultimately in that scenario, it will come down to what are you contacting them about, and is it something that flows from the employment contract, or are you trying to market to them? And if you're trying to market to them, then obviously it would fall outside the contract. So that's where you've got to draw that dividing line.
I think a very good example of this, and again, I'm aware of it because I have to deal with it, is references. A number of ex-employees, we make all of our ex-employees sign something to say, yes, they are happy for us to provide a reference. And therefore, this is just another of those areas where actually we need to retain something about our past employees so that we can contact, or allow ourselves to be contacted and then go back to people who might be new employers.
Absolutely.
Good. Another question from Kay. As a therapist, how long can I keep their records, especially as some come back after months or years?
Yeah, so I suppose the first thing that I would say, Kay, in your scenario, is that the type of personal data as a therapist that you're going to be holding is what's currently called under the Data Protection Act sensitive personal data, but under the GDPR is going to be called special category personal data, which broadly speaking is things like details of someone's race, their ethnicity, their political or trade union views, but crucially in your case, medical records. So as a therapist, it's likely that you will be holding some degree of medical records or medical information on that individual. So how long you keep that data for needs to be taken in the context of the fact that it's quite sensitive data that you're holding. That said, if and I know there's certain legal requirements for certain documents actually to be kept under sort of medical or health and safety law. If it falls within one of those categories, then you can follow whatever the law is. And I know some documents can be kept for up to 40 years. But again, it comes down to this question of being able to justify. If you can show there is a pattern of of your clients coming back and saying, can I have this information or that information? And there's a bit of a trend in terms of how long it's been, then you record that and you justify it. And as I said before, the ICO are probably going to be unlikely to attack your justification if it's been properly thought through. Now, that said, you've got to be aware of the fact of a potential data breach, because if there was a data breach in your scenario, then the potential risk and harm to the individuals would be much higher than, say, just a name and address. So it needs to be taken into consideration. Whatever you do, you need to tell people in your privacy notice, whether it's on your website or whether it's in hard copy, that how long you're keeping their data for, or if you don't know a specific time, then what the criteria is for keeping that data. So communication is key in that scenario.
You mentioned data breaches, and that's actually our next slide dealing with that. What changes are being made to the rules around data breaches? What do I have to do under the GDPR if I discover a breach? And I think it's quite helpful here just to talk about potentially what constitutes a data breach.
So there's two questions in this area that now have been introduced under the GDPR. One, as you absolutely say, Jeremy, is what constitutes a data breach, and then the second question is what do you need to do about it? So if I address those in turn, a data breach is incredibly wide. The definition of the GDPR is effectively anything adverse that happens to that information. So, for example, accidental or unlawful destruction, unauthorized disclosure, unauthorized alteration or variation. So it really can be as wide-ranging from the building burning down and all of your records and your server going up in flames to sending an email to the wrong person. Now, I'm fairly certain for those who are listening, if your building went up in flames, the first thing you wouldn't do is say, what are the data protection implications? But nonetheless, it would still be a data breach, so it still needs to be considered. So sending an email to the wrong person, if it contains personal data, is a data breach. Obviously, leaving a laptop on a train or in a cafe, sending contact lists to your own personal email address could be a data breach. It's incredibly wide. And then obviously you've got the extreme scenarios of a Cambridge Analytica or Uber style scenario. So those are the sorts of things that would constitute a data breach. And important to say as well that it's even if no one has accessed that information, or even if no one can access that information because it's encrypted, it still constitutes a data breach. But you then have to come on to this next question, which is, well, that's all well and good, but what do I actually have to do about it? And under the GDPR, there are now some new reporting guidelines that need to be followed. So previously, under the Data Protection Act, there was no requirement to notify the ICO or to notify the individuals, although obviously it's best practice. Under the GDPR, there is now a formal requirement to notify the ICO in certain scenarios. And there's also a formal requirement to notify the individuals themselves, the individual data subjects in certain scenarios. And whether or not you need to follow that notification procedure will all come down to a question of what is the likely risk to the individual in question whose data has been breached. And if there is no or very little risk, then you can probably avoid telling either the ICO or the individual themselves. But if the higher it goes in terms of risk, the much more likely you're going to need to notify. So when we're talking about risk, we're ultimately talking about, well, what volume of personal data has been breached and how sensitive it is. Because you could have one individual's medical records having been breached, pretty high risk, or 600,000 strong marketing list with people's just names and email addresses. But again, it's still a pretty high risk. But compare that against an email to the wrong person. So Jeremy, if you sent an email to me that was meant for another Alex and you said, please delete it, and I deleted it, then obviously that's going to be pretty low risk.
And again, it's another of those areas, I think, whereby if people have thought about and they have policy documents in place in terms of what constitutes a risk, who needs to be notified, and any follow-up actions, this again shows that this has been considered and thought about, and therefore there is a plan of action in place were it to happen, as opposed to just thinking, well, we'll make it up as we go along type thing. I think this is where more of it, all of us now under GDPR need to document exactly what constitutes a breach, make sure that all members of staff know about it and are able to do something if they feel, even however minor, there is a process in place that they can easily follow.
Yeah, that's a really good point. The two key documents there are a data breach policy and an internal breach register.
Yeah.
So those are things that all organisations will need to have.
Going back to some questions here, a question from Tracy that sort of regards potential clients, and this is an interesting one. Again, I'm sure impacts ourselves, your firm. Tracy's basically saying, they gather information from potential clients who might request a meeting about initial advice, general practice, corporate recovery. Do we need to get consent from them as a potential client? And I guess this is a case of saying, if they don't sign up or engage you after that initial meeting, can you then keep that information? Do you need to get them to sign up at the meeting and get their consent for future contact? How best to deal with them?
So when we talked about that contract basis earlier, so that you don't need to get consent where you've got a contract with the individual, that actually also applies to taking preparatory steps to entering into a contract. So the kind of pre-contractual negotiation, if you like. So if it's an individual that you're dealing with, come in, you've had some initial discussions with, then it's using their information for those purposes will be covered by that ground. Where it's a business, you're probably going to be relying on some kind of legitimate interest ground to be using that information in the first place. And then in terms of how long you retain it for, it all comes back to what policy have you drawn up and how are you justifying keeping that data for a particular period. If you can show and you can evidence that actually, prospective clients that didn't sign up have come back 2-3 years, in 2-3 years time, and then engaged your services and you needed that information, then that's how you justify it. But I would suspect with prospective clients that you don't need their information for years and years and years if they haven't signed up for the service.
But if we have an individual, a private client who maybe wants some tax advice, who comes and has an initial meeting, we haven't engaged them at that point, they decide not to engage our services, but we have contact information from them as part of getting the meeting set up and what have you. Are we then able to contact them after that meeting, having had their information freely from them, or do we need to formally get them to tick something if we feel that we'd like to keep them on a database for the future?
I think you need to decide what you're keeping them on the database for. If you're doing a follow-up saying, we had that initial meeting, what do you want to do? Are you planning to instruct us? Then that flows from the potential contract that you're going to enter into that person. If you just want to keep them on the list for marketing purposes, to invite them to events, so on and so forth, then in that scenario, you would need to get consent. And remember that most organisations should, by the time 25th of May rolls around, have some kind of privacy notice or privacy policy. And I know that M&A will have a brand spanking new one come the 25th of May. That will set out how data is collected and how it's used. But for the likes of, if you just want to stick them on your marketing list, you would need to go and get consent.
Yeah. A question here, and it's one that actually I've heard similar ones, whereby there are a number of organizations that have over time accumulated contact information, names, things like that. This one from Janet talks particularly about a parish council that has a list of residents to contact about meetings and news relevant to people in the community. Is that allowable? And what about if we have an informal list of friends or interested people? They can, of course, ask to be taken off the list, but how do you get them on the list in the first place? Do you send them an unsolicited email and hope they'll get back to you?
So in terms of if those people are members of something, not some kind of organisation, then although there's no written contract in place, you effectively have
implied contract.
Exactly. And therefore you would rely on that basis. If not, it would seem like legitimate interest is going to be fairly key there, because the reality is that if someone said, could you stop contacting me, you would have to take them off.
Yeah.
But if you're just contacting them about things that are going on, for example, in the parish council, then either you'd rely on the fact that they're a member, or you'd rely on legitimate interest in that situation.
And I think that again, that's a useful point to start, which is, I think GDPR isn't trying to catch people out. It's just trying to make sure that we all think a bit more about the information we hold. And ultimately, the majority of people who receive information will want to get it. And, in the example of this one, I'm sure there are people as part of that community who will want this information. Inevitably, there will be odd occasions where somebody will say, I don't want it. And it's then a case of making sure that they are taken off the list and, dealt with accordingly. Moving on, Joanne, we send password protected payslips to employees via email. An employee has requested us to send it to his wife's email address. We have this in writing from him. Would this cover it?
Yeah, I mean, if there's nothing stopping that individual directing you where they send information, if you've got it in writing and within that email you've confirmed that it's the correct email address, and it's definitely come from the employee in question, then yeah, absolutely, because you're just following that individual's instructions.
Yeah. A question from Kerry. If you're sending a fundraiser a thank you letter after they've raised funds, are you allowed to include flyers for up and coming events in the post? And this is an interesting one again, because it's hard copy post communication versus electronic email.
So we've deliberately avoided going into this too much, because it can get rather complicated in terms of various different bits of law. But just to make things worse, there is another bit of legislation that runs alongside the GDPR, or has actually preceded the GDPR by some time, which is the Privacy and Electronic Communication Regulations 2003.
Sorry, I've just fallen asleep.
And it has obviously been around for quite a long time. That deals specifically with direct marketing. So a lot of this consent is actually coming from that bit of legislation, but it's sort of just being bundled in to the GDPR. Now, post is much more lightly regulated, and therefore, if you are sending things in the post, it's most likely going to fall outside of the GDPR, and it's going to be much more lightly regulated under that bit of law that I've talked about. Now, I say it with quite a heavy caveat, which is the ICO and UK Parliament are intending to bring in a replacement for that bit of law, and they were planning to do it alongside the GDPR rather ambitiously.
Yep.
That's fallen flat, as you might expect. They've said that this new bit of law is going to come into play in June or July, and we'll have a much clearer idea of the rules around hard copy post when that comes into play. But at the moment, lightly regulated, and you don't need consent in the same way.
So, Kerry, keep putting things in the post when you send your thank you letters. We've got our last question, which just relates to, on the screen now, data protection officer, because it's something that people have asked about. I've been told that I need to appoint a data protection officer under the GDPR. Is this always the case? I'm not sure that our organisation can afford this extra resource. Just out of interest, we as M&A partners are not appointing a DPO. I know others are, but it's a question that people have asked, because clearly lots of people are saying, well, should we be having somebody who's our data protection officer?
Yeah, I mean, something I've come across a lot. I have heard and read articles saying everyone everywhere has to appoint a DPO, whether or not you're a sole trader or a massive corporate. Completely not the case. Under the GDPR, you need to appoint a DPO if you're a public authority, and that goes without saying, or if you process, as part of your core activity, large-scale sensitive personal data, or you monitor public areas regularly and on a systematic basis. So what that means in practice is if you have loads and loads of CCTV cameras that point onto public areas, more likely than not to appoint a DPO. If you are an occupational health clinic who processes lots of medical records, more likely than not to appoint a DPO. Going back to Kay, who has a therapy practice, could be an area where you would need to appoint a DPO because Kay may well be processing large-scale sensitive personal data, medical records and things of that nature. But Leathes Prior are not appointing a DPO, and a number of organisations of a similar sort of size are not. So you have to take, again, with all of this, a much more nuanced approach. Don't just believe everything that you read. If you fall into one of those criteria, then yes, you do. But unfortunately, appointing a DPO is not the most straightforward thing in the world. And it comes with a bit of risk and hassle associated beyond the costs, because the individual who's appointed as the DPO needs to have some kind of degree of independence to the ICO. So they need to they can't be conflicted between what the board are telling them and what the ICO are telling them, or what's in the best interest from a data protection point of view. They need to have sufficient expertise and superiority or seniority, and they should be spending quite a lot of their time doing data protection, which I wouldn't wish on anyone. So on that basis, you need to think very, very carefully whether or not it's absolutely necessary. For some businesses, it will be, but for most, probably not.
And so I guess it really boils down to sort of volume and nature of the sort of the information, and therefore making decisions based around that. But certainly, it sounds as though the majority won't need a DPO.
Yeah, I think that's right. I mean, if you look at Leathes Prior, our function is to provide excellent legal services. Now, that's on occasion we will hold sensitive personal data, but it's not part of our core activity. It's not all for every matter, be it corporate, private client, that we don't always hold sensitive personal data. So that's the approach that businesses need to take.
Got it. Craig's got a question. Sorry if I missed this. If a third party is holding our data, such as MailChimp, assuming consent is in place on our side, is it MailChimp who are liable for the security aspect of holding the data? And this comes back to sort of the data processor issue.
Yes, this is an area we haven't really touched upon, and is possibly the most confusing under the GDPR, and it's a concept that's existed under data protection law for the last 20 years. Effectively, MailChimp in that scenario would be what's called the data processor, which ultimately means that they're a service provider doing a particular function on behalf of their clients, and they wouldn't do anything else with that data. So in that scenario, it's going to be crucial for you to make sure that your organization, to make sure that MailChimp has proper security in place. And I would be incredibly surprised if they haven't already updated their terms and conditions to include some kind of statement to that effect. And if not, have a look on their website. I'm sure they'll have some kind of GDPR page. And ultimately, it's about satisfying yourself that they've got proper security in place, because your organization, not MailChimp, would be responsible for any data breach.
Thanks. Kay, I'm only part-time. Don't have more than a dozen clients at any one time. What do I do about obtaining consent at taster evenings, or when I might be giving tasters to, say, Tesco staff? How do you? Is this a sign-off that people need to be getting when they're broadly prospecting, looking for new clients, putting on a little bit of a pamper evening or things like that, whereby you have people coming to visit that ultimately you then want to get their details so that you can market your services to them in the future.
So, I mean, practically speaking, obviously, when they sign up to the event, that's possibly the best time to get consent if you feel it's necessary. You need to look at what your audience is. If your audience is business contacts and this is business to business marketing, remember you may be able to rely on legitimate interests. If it's very much business to consumer marketing, then you will need to get consent in most scenarios, and therefore you just need to streamline it and include it in your kind of process as easy as possible. And like I say, if people are signing up through through the website, then consent there is going to be the place to get it. If not, then remember consent can be verbal. So if people tell you that they're happy to hear from you, then you can rely on consent that way as well. It doesn't have to be something that's written and signed, so long as you've got a record of it.
Good. Question from Ian. As an SME, if an ex-employee makes a DSAR, now you're going to tell me what that is, Alex?
It is, yeah, a subject access request.
Saying they want to check that the personal data we hold is accurate, what do we need to provide, e.g. email content about them? What is it that you need to go back with?
Well, it's good we've touched upon this subject, because there are some changes under the GDPR. Subject access requests have been around for the last 20 years, and the rules around what you need to provide are broadly the same, which is any personal data that you hold on that individual. So it's an incredibly powerful tool that I don't think most employees have necessarily clocked onto yet. But effectively, it will mean that any time that you've used their name, their email address, or some identifier that relates to them, you need to provide them with a copy of that information. Now, you can redact those documents. So you can say, for example, if it's going to put you in breach of use of someone else's personal data, then you can redact it. If it's confidential information, some kind of trade secret, or some kind of intellectual property that's included within those documents, then you can refrain from providing that information. But actually, the rules and the exemptions around responding to a subject access request are incredibly slim. There are going to be very few occasions where you can out and out say, no, you can't have it. To make matters worse, from an employer point of view, the individual now previously had to pay a tenner. It was amazing. That tenner was the best barrier. As soon as they heard a whiff of money exchanging hands, they lost interest. Subject access requests are now free. So you need to verify their ID. You need to make sure they are who they say they are. But ultimately, you need to provide them everything that is, broadly speaking, on your servers or in some kind of filing system about that individual.
Kelly asked a question. It's an interesting one. I work for an organisation that rents offices and units. The local authority sometimes contacts us to request details of a new tenant that has moved in. Are we allowed to give out this info? Most of the time it is businesses as opposed to sole traders, but sometimes it is a sole trader. And I guess this is that sort of differential between B2B and B2C. And the info that they ask for is moving in date and company name.
Actually, I think it's even more straightforward than that, which is that one of the 6 grounds for processing, one of the ones that I actually haven't mentioned, is that you can use someone's personal data if you need it to comply with a legal obligation. And I imagine if the local authority are asking that question, it's through some kind of legal requirement, and therefore you have a complete round to provide that information. So hopefully that's an area that you can deal with pretty straightforwardly.
Good. Julie, we are a B2B business. Our email addresses that are clearly business professional emails and not personal excluded from GDPR rules as not personal?
They're not, no, because it would still provide, that's where you've got to look at the actual email address. So info@Leathes Prior is not identifying an individual.
Yeah.
So not personal data, not covered by the GDPR. Saunders at leathesprior.co.uk is personal data because it identifies me, and therefore is covered by the GDPR. So my view is that they should have excluded business to business email addresses, telephone numbers, but they haven't.
Yeah, just on that one, can Julie send you marketing information under the legitimate interest issue at alex.saunders@leathesprior.co.uk?
Well, you can certainly more likely rely on legitimate interests for business to business marketing than business to consumer marketing. Whether or not, if it was completely from cold and I'd never had any dealings with the organisation, I think that's going to be an area where you're going to be less likely to rely on legitimate interests. But as I said before, business to business marketing is much more likely to be a legitimate interest, and the ICO have spelled that out. And it's a really interesting and hopefully useful bit of guidance for anyone who wants some more information on this particular area. Then that's probably the first port of call, and that can be found through the ICO website.
Will has asked a question: are there ways of sending a statement letter through to your customers with your accounting package such as Sage 1 on it? We might need a little bit more information on that, Will. I've had a slightly sort of quizzical look from Alex there. So if you wouldn't mind just giving us a little bit more flesh on the bones for that one. Jane's come on and said, sorry, I'm a bit late. I've only just joined. Will this webinar be available to access later? Jane, please be assured, we are recording and taping this so that we can get it sent to everybody. So you'll be sent a link, but we'll also, hopefully in the next 24 hours, have it on YouTube so that it can be shared with a wider audience as well. But yeah, it will be made available. So all the stuff that we covered at the beginning, you'll be able to listen to and look to, hear some of the questions that have come up. Is Will there? Because Will's was the last question I think we had, because we've gone through the 6 that we had prepared, with the data protection officer being the last one. So right, Will, thank you. I mean that we have all of our accounts on a Sage program. Is there a way we can send a generic email the same way as we send out our sales invoices to the email addresses?
So some kind of marketing communication. Well, if you've got consent, or you're relying on a legitimate interest, and you're confident you can rely on the legitimate interest ground, then yes. So that's ultimately going to be what the question you need to ask yourself is. And that's the way I'd approach it.
Well, I think this may be one where we follow things up following the webinar, either sort of somebody internally here at M&A, or even getting Alex involved just to provide you with exactly the answer that you need on that one. We seem to have come to the end. Yes, that would be ideal. Thank you. Perfect. Well, that's just what I needed to hear. We seem to have come to the end of the questions now. Where are we? 11:15. Gosh, time flies when you're enjoying yourself. I hope that the last hour and 15 minutes has given you a bit of a feel for how to approach GDPR. It's addressed some of the issues that Alex and I felt were out there and were becoming a little bit of an issue, the myths and things that were happening. And certainly Alex is the man who really does know this stuff, so I can recommend you contact him if you want to know more. We just had another question in from Kay. I have another one, read charity. Do you want to expand on that, Kay? I'm not sure. And that one, again, may be one that I can sense that Kay is typing away furiously here, and I'm ad-libbing a bit, but
yeah, I mean,
here we go. As a charity who offers support, we rely on volunteers registered with us so that they use their own laptops, emails, etc. So difficult to manage, we are creating a policy to tell them how to manage the data, but we rely on them to carry it out. Should we try to get them to not hold the data?
Yes, if at all possible. And I'm expecting, I don't know what type of charity it is, but I suspect that means purely by virtue of the nature that you are a charity, that you may be helping, for example, vulnerable people or children. Therefore, the data that's being held is going to be much more sensitive. So if you can dissuade people from using their own devices altogether, and that's not going to cripple the charity in terms of costs, then it would be something that I would strongly recommend.
Good. I think we've come to the end there. As I said a second ago, thank you all for attending. And what we will do now is we'll do a little bit of tidying up. We'll get this put on YouTube. We'll get this link sent to everybody. And hopefully you found it helpful and useful. As I said, Alex is the man who knows this stuff. And we're very happy to facilitate any introduction from people who've been on the call who want to get in touch with Alex. But hopefully it's been useful. And thank you all for attending. Thank you.
Thank you.